when I saw the article, someone showed it to me. It was in the Newsday, I believe. I was a bit taken aback at the statements therein. If I can summarize what I took away from that article, is that the regulations required to implement the public procurement system have been sitting on my desk for the last 134 days, and that the Office of the Procurement Regulator was not sure what was going on from that article. So let me state what the facts are. On the 18th of December 2019, a letter was written to me by the Office of Procurement Regulation, or the regulator himself, dealing with an issue that we had been discussing for quite a long time. And that particular issue was the whole question of the authority and responsibility of the Office of Procurement Regulation for two types of procurement, namely government-to-government arrangements and public-private partnerships. And we had a lot of discussion stretching over quite a long period in the latter half of 2019. This is myself, my staff, and the Office of the Procurement Regulator with respect to whether or not Section 7 of the Public Procurement and Disposal of Public Property Act should be amended to exclude those two types of procurement from the purview of the Office of Procurement Regulation. So we had a lot of discussion, a lot of back and forth. And initially there was a view that they should be. But eventually on the 18th of December, and the reason is that these things are very unique and very complicated. For example, it would be very difficult to enter into an agreement or contractual arrangement with a sovereign government such as the government of Australia, the government of China, government of the United Kingdom, etc., to supply goods and services to Trinidad and Tobago, and then subject that government to the Public Procurement Act, because the other government may simply not be willing to do that. There may be certain things in the Public Procurement Act, and there are, that would complicate the matter tremendously. And what it would in fact do is it might ensure that we no longer would have any government-to-government agreements for the supply of goods and services between Trinidad and Tobago and another sovereign government. So that was the nature of the discussion, going back and forth for quite a long time. But on the 18th of December, the regulator wrote and said, we want to maintain our position, and they felt that they should not, this was the latest position to regulate on the 18th of December, that we should not seek to amend that section with respect to government-to-government agreements. This position had changed several times in the discussions. The office also told me, this is the regulator, that despite the mandate of the office to dispose of real property, the office should not be responsible for direct disposal of any assets, inclusive of real property, as this will be a direct conflict of interest as it relates to its regulatory function. The office proposes, this is the regulator writing to the Minister of Finance, that the said section should be amended for the office to advise or provide general guidelines on best practices to all public bodies charged with the responsibility for the disposal of real property. So this was the final bit of correspondence we got from the regulator on the 18th of December, giving us a final position from that office with respect to amendments to the Act with respect to government-to-government arrangements, public-private partnerships, and property. So what the regulator eventually said on the 18th of December is you need to amend the Act, or we are proposing that you amend the Act to remove the function for disposal of public property from the Office of Procurement regulation, but with respect to the other matter we've been discussing for some time, we think we should just leave the act as it is, and the backstory to that is that they will try and manage the situation. So if something arises with an international agency or government, sovereign government, and the rules of that government are in conflict with the procurement rules, they'll manage the situation. That was the final position we got. We in the government have discussed this, and we have the firm view that we should not leave this in an open-ended fashion, leave it to ambiguity. And therefore we will be going to the Parliament when the Parliament is available in February of this year 2020 to address that whole question of how government-to-government agreements for the supply of goods and services are addressed. We don't think it should be left open, because it will be subject to tremendous interpretation, ambiguity, and confusion. So we're going to clarify the law with respect to government arrangements. But notwithstanding that, the regulator has asked us to remove from his function the responsibility for disposal of real property and assets, public property. So we'll amend the Act to deal with that as well. And then the whole question of the regulation sitting on my desk for 134 days, Section 63 of the Public Procurement Act states that regulations made under that section, which are the regulations that were referred to in that article in the Newsday, are subject to affirmative resolution of Parliament. The last sitting of the House of Representatives was on the 16th of December 2019. The letter from the regulator is dated the 18th of December 2019. Therefore, it came 2 days after we had the last sitting for December in the old place of the Parliament on the waterfront. The grand opening of the Parliament will be on the 24th of January. On the 27th, we are going to Parliament to deal with a routine matter, which is the closing of the accounts for fiscal 2019. The accounts must be closed within 4 months of the end of the financial year, and therefore the accounts for 2019 have to be closed by the 31st of January 2020. That's 4 months exactly after the end of September. So that the first order of business will be the closing of the accounts for 2019. It's not complex matter. There's just one item that we have to address, which is moving some money around where there have been savings towards the payment of debt servicing. One item is being moved around. That will take place on the 27th in the House, and then we'll go to the Senate on the 28th, and then the Act will be assented to on the 29th. That's our timetable at this point in time, and therefore we will meet the January 31st deadline. At the next item of business, which will be in February, because we also have an insurance amendment to do in keeping with international obligations, and we are looking at doing that on the 31st of January. Important amendments to the Insurance Act, which have been recommended to us by the Central Bank after consultation with the IMF and other regulatory agencies. So the plan is to do that on the 31st, Friday the 31st. And therefore, the first opportunity to debate the regulations that will bring into effect the Procurement Act will be in February 2020. The point I want to make, if the Parliament went on recess on the 16th of December, and if the Parliament cannot convene to debate the regulations until February 2020, then what is this story about these things sitting on my desk for 134 days? And if I received a letter from the regulator settling these matters on the 18th of December, 2 days after the Parliament went on recess, then what is this talk about the things sitting on my desk for 134 days? I just thought I would clear the air.
In terms of the procurement regulations, so once the debate occurs in Parliament and so on.
Well, the first things we're going to do is amend the Act. The regulator has asked for an amendment to take from his office the responsibility for the disposal of public property. So we're going to do that. We agree. he says he needs to regulate it, not be responsible for it. And the Act, as it currently stands, his advice is that it makes him responsible for the disposal. So we're going to do that. We're also going to clarify the law with respect to government arrangements, because it's not acceptable at this point in time. So it has to be done. We will table the regulations at the same time that we debate the amendments to the Public Procurement Act. And then at the earliest opportunity after that, which won't be long, we will debate and approve the regulations. That will take place in February. It cannot take place before that. It could not have taken place before that. And that's really the point I was making.
So then once that happens in February, or is there another procedure?
No. The sticking points were the regulations. We had to do a lot of work on the regulations that were submitted, a lot of back and forth dealing with what was submitted, because some of it was outside the purview of the Act. That was one of the issues. So we've more or less settled those. There's some fine-tuning we still need to do on some of the regulations, but that's all right. And we should have that ready when we go to the Parliament in February to debate the regulations. We should have those few points sorted out. So it's amendment of the Act early in February, and then shortly thereafter, debate and passage of the regulations, and that's all that is required to complete this process so that we can implement the public procurement system. Okay?
Had we not implemented in the current form and have the amendment brought to Parliament? I'm simply saying that because there's a view that this particular legislation has taken so long, and that so many contracts have been handed out since between its passage and implementation. And the view is sometimes that maybe government wants to get certain things done without the humbug.
That's precisely why I came here. The answer is no. You have to resolve these issues, because once you debate the regulation, let me explain what the regulations are required for, or what they are required to do. The regulations are the rules. The Act cannot operate without rules. So you must have rules. The regulations have to be debated and approved by both houses of Parliament. So you can't implement the Act unless the regulations are tabled, debated, amendments made as thought necessary, and approved by both houses of Parliament. And these two issues are very important. The whole question of the disposal of public property, including real property, we're talking about land. The regulator has concluded that he should not be responsible for the disposal of land. He should simply be able to examine what is being done by the government in the disposal of real property and other state assets. That his function is regulatory. So he's supposed to examine, critique, investigate the disposal of land by the state, not that he should be responsible for the disposal of land. So that's a very important amendment to the Act that needs to be done, and that was contained in his letter of December 18th to us. And then the whole question of government to government, we've been back and forth for months on this, and it needs clarification. So those two matters need to be dealt with. They will be dealt with in February, and that clears the way for the debate and approval of the regulations. Okay? But it can't be done in a piecemeal manner.
Is there a problem with the regulator's position is a variance from the government's position, and the government has goes ahead with amendments, because you said that the question of the government-to-government contracts.
The law and public policy is a matter for the government and the Parliament. That's not a matter for the Office of the Procurement Regulator. It is the Parliament and the government that needs to determine how government-to-government arrangements should be treated. The regulator and his officer, they are implementers, so that the policy is set by the state in consultation with stakeholders, etc. But it is the state that has to set the policy and then take it to the Parliament for passage. It's not, I don't want to use bad examples like the tail wagging the dog or anything like that, but it is the policy, any public policy is the responsibility of the government and the Parliament. It's not the responsibility of an agency. Agencies don't set policy, they implement policy. Okay?
Was there a reason as to why the government would have wanted the regulator or the office to deal with that issue of sale of assets?
It's just one of the problems with this act is that when it was being debated under the former administration, we pointed this all out. If you go into the Hansard, we said this, and we were ignored by the previous administration. So what has happened now as the regulator begins to build out his capacity, hire staff, get legal advice, etc., these things have come to the fore. But it's something that we pointed out long ago, that you have to address this. The way it's currently worded, any government-to-government contract is subject to the procurement regulations. That doesn't make any sense. Because if a government wants to donate an aircraft to you, for example, I know the Minister of National Security has some old aircraft that he insists on flying in, which he's taking a chance every time he flies in them, in my opinion. But if, for example, the government of the United States hypothetically wanted to give the government of Trinidad and Tobago aircraft or ask us to buy aircraft from them at a reduced price, as the case may be, the Office of the Procurement Regulator should not really be coming into something like that at all. But that's the way the Act is structured right now, that any procurement of any kind whatsoever, including government-to-government arrangements, are subject to the strictures of the Office of the Procurement Regulator. It just doesn't make any sense. No foreign government will want to do business with the government of Trinidad and Tobago if everything that it wants to do in terms of providing goods and services to the sovereign state of Trinidad and Tobago is subject to this third party. They just wouldn't do it. So we need to provide clarity on that. That was a sticking point long ago. It's a sticking point now, and we're now going to deal with it. So it will be dealt with in February. After that, it's just to debate and pass the regulations, and that's the end of the matter. Then the thing goes into operation. Okay?
The sale of, as you said, land and assets and so on, the existing system, whatever it is, will prevail, or it's of ministries or governments instead of the regulator dealing with it, as you said?
It would be a matter for the state. Okay?